Hello everyone, welcome to Master Stage. And today we are going to discuss labor law second unit. We'll discuss detailedly about the prevention and settlement of industrial disputes. Okay, so basically we deal with Industrial Relations Code 2020, and which is very important for your examination purpose. Let us see one by one so that you're going to have full information. So in this unit we are going to discuss prevention and settlement, so where mechanism between industrial disputes and resolution. Then what is the government role, so how the government intervenes in industrial relationship. Then key definitions, we discuss industry, workmen, dispute, strike and lockout. Then special provisions, so layoff, retrenchment, closure procedures. Okay, let us see prevention and settlement of industrial disputes. So the objective of this prevention and settlement of industrial disputes is that uh, in order to have the peaceful environment in industry, okay, there is a harmonious relationship between employer and employee. So the relationship through structured dispute resolution mechanism, there is a proper way to solve any disputes. Okay, so historical evaluation, if you see here, IDA Act 1947, that is Industrial Disputes Act 1947, then Industrial Relations Code uh, 2020, so which is consolidate more friendly one. Okay, so here how this industrial disputes can be settled in harmonious way. This is the flow. Okay, where works committee, so both the parties, first whether it is employer or employees, so first they have the for talk. Then then in between, conciliation, so conciliator, the government appoints the conciliator to facilitate the talks. Then even mediator also comes into picture, and he'll guide the resolution for the dispute. Then if it is not solved, then it goes for arbitration. So one has to bind the decision made by the arbitrator. If still it is not solved, then it goes to the education. Okay, that means industrial tribunal legal ruling will take place. So first the disputes are settled through works committee, that is both the parties have the dialogues. Okay, then government appoints the conciliator to facilitate the settlement. Then mediator, the neutral mediator, is not support to the employer or employee, and he guides for the resolution. If it is still not possible, then arbitration. So one has to bind the decision made by the arbitrator. Then if still it is not solved, then adjudication, so industrial tribunal legal ruling will happen. So this is the uh, hierarchical dispute resolution mechanism under Industrial Relations Code 2020. Okay, so one has to follow this the hierarchy. This is the way one can solve the dispute in harmonious way. Then role of the state in industrial relationships. Okay, what is the role of the government? State means government. So government is like acts like a regulator, ensuring that they are going to comply with the labor laws and maintaining the industrial harmony. They want to maintain the peacefulness in the industry. At the same time, according to the labor law, the labor has to follow, and industry also follow the same. Then uh, then union recognition, so that means a recognition of negotiating unions for collective bargaining represent for workers. So they call the unions which is recognized by the government, okay, to represent the worker to solve the problem. Then conciliation officers, then government appoints the officer uh, to facilitate, to help, to resolve the problem. So the facilitator appointed mediation between uh, laborers as well as management of the company. Then it goes to industrial tribunals. So establish tribunals for adjudication complex industrial disputes. If the dispute is more complex, then it will hand over to the industrial tribunals. Then uh, government also have the power to probate, stop the strikes and lockouts during the conciliation proceeding to maintain peace. If the conciliation or if the negotiation is going on during that period, the government can have the power to stop the strikes, to stop the lockouts during the negotiation or during the discussion in order to maintain the peace or harmony. So, this is the role of the state in industrial relationships, or the role of the government in industrial relations to be maintained. Okay, first he acts as the industrial regulatory authority. Then he calls recognized unions. The government appoints the conciliation officers. If it is still not possible, then go for the industrial tribunals. Then the last step, they can probate the strikes and lockouts during the conciliation proceedings. Okay, so the key definitions of Industrial Relations Code 2020. One is industry. What is industry? It is a systematic active for production, distribution of goods and services. Industry may be, it may be production, or it may be service, it may be distribution, logistics, or everything comes under industry. For example, the case is Bangalore water supply 1988, 1978. Then industrial disputes. So there is a dispute between employer and workmen co- connected with the employment terms. When why dispute comes? If the employee not satisfied with the work or payment what the employees gives, then the disputes may arise, or employer may complain that workers not work properly, or doing strikes, something like that. Then the industrial disputes comes in. Okay, what is workman? The person who employed for, where it is manual worker, where it is skilled worker or clerical worker. So but excluded here managerial staff, that means directors, managers, these are not included in workmen. Only the person who does manual work, okay, practically they work manually and they have the skills. And clerk also comes under workmen, but it excluded the managerial staff. Award, that means final decisions or final word given by the industrial tribunal. So one has to obey that particular award or final judgment. Mm, particular parties means it may be uh, workers as well as employer. Then uh, industrial versus individual disputes. So industrial dispute means it is affected group of workmen. So many people have the um problem with the particular dispute. Okay, not single man. Individual dispute means it is affected only single workman. Okay, so industrial disputes, it's a collective interest, whereas individual disputes, it's a personal problem. Then here union can uh, help here. Then the union can be represents for the industrial dispute, but individual dispute one has to fight for uh, alone, and there may be less chances of union work for them. Okay, then wider impact. If the industrial disputes taken place, then the impact is more on the in the country or in the particular industry. So if the individual disputes, there is no that much impact. It is only small scope for dispute. Then strike and lockout. So strike means cessation of work by workmen, whereas lockout means closure by employer. Strike means employees will strike, they won't work. That is called a strike. Lockout means the employer, the the person who runs the business himself close the particular factory. That is called as lockout. Okay. So special provisions related to the workmen. So will here layoffs, here a high protection, low protection, lower employer action, high employer action. So in layoff there is a temporary suspension. Okay. Then retrenchment and permanent termination, it is a high protection when the this IRC is implemented. So here you check here, key distinction. What is layoff? Layoff means temporarily inability to provide work, compensation payable, government permission required for in certain establishment. So it is, so the employer unable to provide the work, maybe due to less raw material, or maybe due to excessive production, or some other things. So they cannot continue their work. That is the reason they lay off the workforce. In order to lay off, that the employer need to take the permission from the government. Okay. And retrenchment. Retrenchment, it is a permanent termination of the employees from the uh, industry or factory. So for that, a notice is required. Then the compensation money has to give. So it what happens, last come first go. That means those who are appointed recently, they have to leave the organization first. Those who are working for the many years, they can go last. That is a last come first go. The principle applies in retrenchment. So retrenchment is a permanent removal of the employee from the organization. Okay. Closure means it is a permanently shutdown of the factory or office. So notice will be given to the government, compensation will given to the workmen, specific conditions apply. Sometimes VRS, voluntary uh, retirement, something happen. So layoffs happen. Why layoffs happen? Due to shortage of materials, breakdown due to some of the machineries not work, then natural calamity due to earthquake, corona, something like. So in that period, during the layoff, they are eligible to get 50% of the basic wage. Retrenchment procedure. So those who are removed from the permanent termination from the organization, they have to be given 15 days wages per year. So government approval is required for the retrenchment done to 100 plus workers. Then closure requirement. So if the organization is closed, then 60 days notice period given to the government, and compensation at 15 days wage per year of service will be given. So these are the special provisions related to the workmen. Okay. Then strikes and layouts. Okay. So legal, in our, if your union is going for strike, they have to give the 14, at least 14 days notice to the employer. So not during the conciliation proceeding, something negotiation going, in that particular period they cannot go for the strike, not within 60 days of conciliation end. If the conciliation end, if the some judgment is came within the 2 months, they cannot go for the uh, legal strike. So must be legitimate industrial dispute. So as per the industrial disputes, okay, they have to follow. Then illegal strike. So if the workers are going for strike without any notice, and during the prohibited period, or in a public utility services without proper procedure. Public utility means maybe transport, maybe the water, okay, something like that. So in that particular field, they cannot go strike without proper notice. So difference between what is strike and lockout: strike by workmen laborers, whereas lockout means it is by employer side. The cessation of work, where closure of uh, workplace. Here people won't go for work. Here the employer himself close the workplace. It is the strike is a collective action, then lockout is a management decision. So its pressure is very tactical. Then there may be lockout, the counterpart from the employer. So illegal strikes may or lockouts attract imprisonment up to 1 month or fine up to the 50,000 rupees. Okay, if you have to mention all those things in your examination to get the good marks. Then award final determination. So award means something goes wrong, then tribunal will give the here an award and final decision given by the industrial tribunal or labor court and industrial dispute referendum. Okay, some like initially they talk, they appoint conciliator, then they appoint the tribunal. If they not listen, then the final verdict come. Okay, so the award is a final decision given by the industrial tribunal or labor court uh, and industrial dispute refer to it. So both the parties, whether it is laborers, whether it is employer, both the parties have to uh, abide the verdict given by the tribunal or the labor court. Then period of operation. So here the period of operation remains force for 1 year from the date of publication of this particular award. Then whatever the award is given, whatever the tribunal given the final decision, that has to be published within the official gazette in 30 days. That this can be enforced in the degree of civil court. Okay, so Industrial Disputes Act 1947 versus Industrial Relation Code uh, 2020. So these are the basic things. You can have the screenshot of this one. Okay, then quick revision what we have learned. We learn about the industry, workmen and industrial disputes, and uh, we learned about the layoffs and retrenchment and strikes and we have also mentioned the Bangalore water supply, industry definition and workmen classification procedures, how the resolution can be uh, given for the disputes. So go through this particular uh, video again and again in order to score the um, good marks in your examination. So learn the like definitions. So try to learn how the layoffs goes on. Then like compare the Industrial Disputes Act 1947 and Industrial Relation Code 2020. Okay, so that you can have the good marks in your examination. Thank you for watching Master Stage. We'll meet in the next lecture with the third unit. Okay, thank you.